Good morning, Mr. Commissioner. It's Laura Tesaro, for the record, Commission Counsel. Before we return to Aboriginal fisheries, we have a brief housekeeping matter that we need to address over the next few minutes. As you recall, Mr. Commissioner, on June 3rd, the Wild Salmon Policy Panel on Strategy 4 concluded, but due to time constraints, neither Council for Canada nor for the Commission were able to conduct their re-examinations. So it was therefore agreed that Canada and Commission Counsel could conduct those re-examinations in writing. Canada did conduct a written re-examination of their witnesses on that panel, namely Paul Ryle and Mark Saunders. Likewise, Commission Counsel conducted written re-examinations of all four witnesses on that panel, namely of Jeffrey Young, Rob Morley, Paul Ryle, and Mr. Saunders. So that's 6 written re-examinations in total, and this morning I would like to tender the questions asked and answered in these 6 re-examinations as 6 separate exhibits. I should note in addition that some of these re-examinations have sub-exhibits, which I'll explain as we proceed. The first exhibit to be marked is a letter containing Canada's re-examination of Paul Ryle, with Mr. Ryle's answers.
That will be marked as Exhibit 1214.
And as a sub-exhibit to this, I would also like to mark a 2008 publication by Jonathan DeRoba and James Bentz entitled A Review of Harvest Policies. Mr. Ryle referenced this publication in his answer, and Canada provided it for the purpose of marking it.
It will be marked as Exhibit number 1214A.
I should also note simply for the record that Mr. Ryle's answer referenced the 2010 Escapement Strategy Memo and provided a hyperlink to that document. That document is already on the record before you as Exhibit 407. The second exhibit to be marked is Canada's re-examination of Mark Saunders.
It will be marked as 1215.
Third is Commission Counsel's re-examination of Rob Morley.
1216.
Next is Commission Counsel's re-examination of Jeffrey Young.
1217.
And next is Commission Counsel's re-examination of Paul Ryle.
1218.
And again, here there's a sub-exhibit to be marked, and I should explain this. The sub-exhibit is Mr. Ryle's revised answer to question 5. Initially, in answering question 5, Mr. Ryle did not have access to Exhibit 920, which was referenced in the question. Therefore, Mr. Ryle provided this revised answer upon receiving access to Exhibit 920. And so if this question on the screen here could be marked as the sub-exhibit.
Marked as 1218A.
Thank you. And then finally, the next exhibit is Commission Counsel's written re-examination of Mark Saunders.
1219.
Here, there are 3 sub-exhibits to be marked, which I should take some care to explain. The first and second sub-exhibit to Mr. Saunders' re-examination are 2 draft tables that he provided in response to question 4, sub-question B. He was asked to provide the current form of the Grant Holt et al. Publication, and we're aware here that the working draft of that paper is currently Exhibit 184. In responding to that request, Mr. Saunders provided Exhibit 184 plus 2 revised tables. And those 2 revised tables we should mark as the first 2 sub-exhibits to Exhibit 1219.
The first one will be marked as 1219A. The second will be marked as 1219B.
And then finally, and I thank you all for your patience with this exercise, is the third sub-exhibit to Mr. Saunders' re-examination by Commission Counsel. Here, as with Mr. Ryle, Mr. Saunders did not have access to the referenced exhibit in answering question 8, sub-question D. Therefore, Mr. Saunders gave a revised answer to question 8D with proper access to what is Exhibit 946. And his revised answer is on the screen now, and it should wholly supplant his initial answer, if that could be marked as the final sub-exhibit to his re-examination.
1219C.
Thanks to everybody for indulging that exercise. Thank you, Mr. Commissioner.
Thank you.
Mr. Commissioner Marquis for the Government of Canada. resuming my cross-examination. I have a maximum of 35 minutes. I hope to get done before then, so I'll be done no later than 10:45 this morning. Continuing on with some questions, Mr. Huber, about the form and roadmap process, and at the end of the last day, we had just started to talk again about the origins of that process, and I'd like to start today with with Canvas tab 30, if I may. Now, this document, the header talks about the Fraser River Salmon Roadmap Background Document. Title is Overview of the Fraser River Salmon Roadmap Initiative. Mr. Huber, do you recognize this document?
Yes.
It's not dated. Can you give me a sense of when this was done, when this was prepared, and who prepared it?
Well, I probably prepared it. I prepared a lot of documents related to that.
Okay.
And it would have been, that would have been more, the forum process started really in 2008. And so that would lead probably 2009, later in the year.
Okay. Perhaps I can mark this document as an exhibit before I go further.
Marked as 1,220.
Looking first of all at the first two bullets under purpose, I'd just like to read this. The Fraser River Salmon Roadmap Initiative is aimed at building a co-management structure, process, and agreement between Fisheries and Oceans Canada and First Nations for the Fraser River watershed, Vancouver Island, and marine approach areas related to salmon. So this is this an accurate description of these two bullets of what the purpose, in your view, is of the roadmap process?
Yes.
Okay. Perhaps one of the things I want to do, we've been talking about the form and roadmap together, and I just want to get some perhaps clarity on the record, is the differences as you see them between the form on one hand and the roadmap on the other. So perhaps over on page 2 we could go next. And in the first bullet, the first sentence talks about the origins of the forum, and you discussed that the other day. I want to go to the next line. Since that time, 2008, the forum has evolved into a Tier 2 and Tier 1 and Tier 2 process for First Nations to come together and with DFO to review technical information, discuss management issues and approaches related to Fraser salmon, and ultimately inform the development of local First Nations harvest plans and the Department's Integrated Fisheries Management Plan. Would you agree that's a description of what the forum is doing?
Yes.
So getting from this, it appears that it is a technical and advisory body for DFO and the First Nations, and perhaps the decisions with respect to allocations and other issues are made elsewhere?
Well, there are recommendations are made to the department from participants on management actions. The way the consultation process works now, still after receiving those recommendations, the department makes decisions.
Okay, and from a First Nations perspective, my understanding this is not intended to be a decision-making body.
Not at this time, but in the future, with the right political engagement, it could be.
Okay, and I just want to go to the next bullet, and distinguishing, I guess, the roadmap initiative. It says here, while the forum provided a good venue for Tier 1 and Tier 2 discussions regarding the FSC fisheries, it was widely recognized that a more formal and comprehensive co-management agreement would benefit both DFO and First Nations, and I guess that's what we've been talking about. Well, I'd like to go down to the last line. There was general agreement by participants to continue the roadmap initiative as a separate process aimed at establishment of a more formal, long-term arrangement for management of Fraser salmon. So is that what you're talking about, that this could become, at some point, a more permanent arrangement?
That's correct, and it would be more comprehensive, broad-based. It would include like other issues that First Nations are interested in, like stewardship.
And would the idea there be that this more permanent arrangement would be more of a decision-making, I guess a politically based body?
Not in itself, but it would, in the process, in the outline of the roadmap, it would show where the decisions are made.
Okay.
Roles, responsibilities, accountabilities. Everything from, it would look at linkages to the First Nation Fisheries Council right down to the First Nation or individual band level.
And I'd like to return to that in a moment. I just want to finish with this document, then we'll get back and follow on that theme. Perhaps we can go back to page 1. Under introduction, a third bullet under introduction. It says, to date, the Roadmap Initiative has had strong participation from First Nations technical and non-technical advisors, with some limited participation of political leaders. Both DFO and First Nations have indicated that greater engagement on the part of First Nations political leaders will be required in order to establish a framework for developing a co-management process and structure, as well as ultimately negotiating and endorsing an agreement. Do you agree that this is one of the challenges and one of the challenges facing the roadmap process is getting greater engagement from First Nations political leaders?
It is a challenge, and they have many responsibilities, so I can appreciate the situation.
Yeah, I didn't mean that necessarily as a criticism, but just as would you agree that it would be essential to have that political engagement for this?
It
to go
is,
forward?
and that's envisioned through the Tier 1 process.
And to be fair, it's also something that could be said of the federal government as well, the need to
Yes.
engage with mandates. Okay, maybe go over to page 2, please.
This, just to correct now that we've been going through it a bit more, Corey Jackson and I would have been the primary developers of this document.
And I just want to go over to where it says who is involved in the Roadmap Initiative. And it talks about who's coordinating the Roadmap Initiative, a body called the Fraser Salmon Roadmap Planning Group, which consists of appointed members and alternates from the following organizations: Fraser River Aboriginal Fisheries Secretariat, Island Marine and Aquatic Working Group, First Nations Fisheries Council, and DFO. One group that's not on there, and this is maybe a question for Chief Terry, is I don't see the Intertribal Treaty Organization listed. Is there a reason for that? Are you involved in the form and roadmap process?
I was involved in the initial stages of discussion regarding the inadequacies of sharing of a diminished resource, which really prompted the initiation of this body. But this has evolved to a different stage now, and it's not the really the ITO or the Intertribal Treaty Organization is quite a different approach to how these management has to be approached.
So the Intertribal Treaty Organization, would it be involved further down the road if and when a more comprehensive formal co-management process is developed as a result of this roadmap process?
Like I indicated the other day, I think there needs to be an understanding reached between the Government of Canada and our respective peoples or nations to make an arrangement on how we shall a relationship that we can live with regarding management of the fisheries.
I'd like to follow on that, and I'd like to go to Canada's tab 10, and I apologize, Mr. Len, about, I know it's an exhibit already. This is the 3-year strategic approach. I'm sorry, Mr. Jones, Chief Jones, I'm sorry I missed that.
I'd just like to add, since we're discussing kind of the participation of various organizations, it does mention the First Nation Fishery Council, as being involved, and that mainly has been as a observer in the process. Although some of the members of the First Nation Fishery Council, such as Ken Malloway, are involved in the watershed. So I think there is kind of involvement from political leaders who have connections, I'd say, to the Fishery Council or possibly other organizations. So I just wanted to note that even though the organizations might be named here, there are leaders from who are involved in these processes that are also engaged.
Okay, thank you. Actually, it's Exhibit 290, and on page 3. And under number 2, further collaboration, third sub-bullet. And I just want to know, this document is dated September 27, 2009, and it talks about, maybe we should go to, just to set the context, go to the previous page at the bottom. And this was supposed to be a list of the year 1 activities, and recognizing, I think the evidence has been that some of these dates have slipped. Go on to the next page then. So this is year 1 activities to happen in 2009, 2010. And I just want to know if this took place. It's a meeting under the third sub-bullet under number 2, a meeting with the Intertribal Treaty Organization and the First Nations Fishery Council representatives to clarify the areas of interest and management of Fraser salmon stocks, as well as associated planning processes and representation. I'm just curious if that meeting actually took place and if any progress has been made toward that end.
I believe that there was a meeting that transpired, but the Intertribal Treaty Organization was not a part of that, or there was an assessment of some kind of an relationship building exercise, but we were not part of it.
Chief Jones?
Could you repeat the question?
Oh, sorry. I was just wanting to know if you had any knowledge about whether this meeting took place as scheduled in this document between the First Nations Fisheries Council and the Intertribal Treaty Organization.
I'm looking at where it mentions
this is
First
on,
Nation Fishery Council.
Page 3, number 2, third bullet, and it says, a meeting with the Intertribal Treaty Organization and the First Nations Fisheries Council representatives is planned or would take place. This is prospective at the time. And I just wanted to know if that had taken place and if there had been any resolution.
I don't believe that meeting took place either.
Okay. I'll leave that. I just want to return and step back a bit and ask some more questions of Mr. Huber about the forum and roadmap generally. Mr. Huber, do you envision that the forum and roadmap processes, however they turn out, will be permanent as they're set up now, or do you expect that they'll lead to, and I think you maybe already answered this, or will they lead to something different, something more permanent? Are these transitional, or are they expected to be permanent?
They're transitional, although the forum, because it's worked well, will be, I think, it's an annual planning process, so it will be established. Maybe it'll be called something different. But once an agreement, I expect to come out of the roadmap process an agreement with the First Nations in the Fraser and the Marine Approach areas on how we'll engage, how we'll work together, and the scope of activities that'll include. And I expect the forum to be a part of, as a result of the agreement, an ongoing occurrence.
And following on that, would you expect that if as something that comes out of this process is a province-wide co-management type process, do you expect that it will replace or substitute for the necessity currently for Canada to consult directly with First Nations at a local level?
No, there will still be some requirement at a local level. I expect, as in most agreements, that not everybody will participate. So those that participate will describe in the agreement how the engagement will occur. And maybe even in that description there may be local engagement as well. We will be looking, the department through its AROM, its programs, to build in efficiencies in our communication. So as we spoke the other day about a tribal representation as opposed to First Nations and a decision-making authority, that's an advantage that I would see, and I think the department would see in this process, in the final agreement, to where we can get economies of scale.
And there was an interesting document that Ms. Gardner put up the other day. I think it was PNCMA, and it was a model where if First Nations at an individual level fed into maybe a tribal or regional aggregated level, and then fed into a more province-wide or watershed-wide level, and then fed into ultimately a Tier 3 process. Is that one model that you have thought about or envisioned as
Yes.
the ultimate outcome? Maybe sticking with that model, what elements, assuming that such a model can be put in place, what elements of co-management between First Nation, I'm sorry, Chief Jones.
I just wanted to add, since we're getting into kind of different models for co-management, some work that the First Nation Fishery Council has done is do a survey of First Nation organizations that are involved in various activities, in the watershed. And it is kind of looking, I think any kind of model that we look at, is going to have to look, we'd be looking for some efficiencies in kind of how we operate, but in some ways it's going to be a kind of a different organization, than the ones that are there now, or there'll be some changes, I'd say.
Okay.
Right.
And I guess the idea from what I'm gathering, is that at the end of this process, there will be a model that'll define how the co-management would take place at the different levels of engagement. So for example, what's going to be decided at a local level versus what's going to be decided at a aggregated regional level versus what's decided at a province-wide level. Is that the idea?
That'll be part of it. I mean, there's a whole communications technical support. We'll build the linkages, including with the Regional and First Nation Fisheries Council. We're trying to build this from the bottom up. We would like the ITO to participate and be on our planning group. The invitation's been there because we want all those interests that we would engage with to help build this.
Yes. Chief Chair.
I think we need to keep in mind the kind of mandate that we have, and under the structure that's been established with the Intertribal Treaty Organization, it is a mandated process. That is, that those folks involved are elected people, and they are given a particular mandate to pursue, and so therefore I think that needs to be kept in mind in establishing various processes.
I'd like to switch focus a little bit then at this point, and first of all I want to talk and maybe ask a question of Chief Jones about the Guahanas Agreement. I raised this with Gujau when he was here in December and talked a little bit about the same subject matter, so I was pleased to see it came up the other day. One thing about the Guahanas Agreement, as I understand it, is that it's an innovative agreement because the parties to it, the Council of the Haida Nation and the federal government, and I guess the provincial government more recently, have agreed to set aside their differences with respect to issues of jurisdiction and focus on a consensus model for co-management of the Guahanas Park. Is my understanding correct, and how that's essentially structured?
That's pretty close, but although it's the agreement with the federal government on the Haida, and on the federal side it's Parks Canada, Representative of Environment Canada, and Department of Fisheries and Oceans. The province gave up their interest prior to kind of the establishment of the area under the National Parks Act and the National Marine Conservation Areas Act.
Yeah, and I think we saw there was a separate agreement that had been entered into with British Columbia. Would you agree that one of the reasons that this Guahanas Agreement has worked well is because the Council of the Haida Nation are united internally in providing a mandate to its representatives on that park board?
I'd agree that has been a significant factor. We have a governance framework that has been in place for a number of years. It involves a Haida Constitution, which has been agreed to, by the citizens of the Haida Nation, and it also mandates we have an elected council and a president and vice president who represent us, and so it provides something that the representatives on the Archipelago Management Board, there's currently 3 Haida and three federal representatives. Haida representatives can bring things back to kind of for decision within that Haida Nation process. And I'd say that in the Fraser, there's potential also to kind of develop that governance framework, and I think Chief Salteri, was talking about the work he's been doing, right? But I think that has happened with many other First Nations, in the province, and I think also it can also happen around specific issues. I know that you saw the other document that was entered about the working models for collaborative management. Mm-hmm. Governance is a big part, of effective co-management, and it provides a way for First Nations, I guess, to bring their interests into a kind of a discussion or a negotiation. But it takes time to put in place, and I think in the Fraser, I think that's what we're seeing over these past few years is kind of that effort, both to identify kind of what needs to be done, but also, how First Nations would be involved in kind of decision making.
I wanted to also point out that in Guayana's arrangement there, I think that's a demonstration of a mandate being pursued by the Haida and a willingness on part of the government of Canada to interface with them. And I believe that's good, and they're providing a united effort there is very important. But I'm kind of jealous of them because of the fact that they're geographically located in a manner that it really fits in with what I believe used to be called the blue water policy. That is, they're not connected directly with the land mass of the rest of Canada, and so I think that their reality is quite different than that of we in the nations within the Fraser River watershed areas.
Maybe I'll just add that that agreement just didn't happen overnight. That it from the time that the Canada established the area as a national park reserve until the Guayana Agreement was signed. It took I don't remember, it was 5 or 6 years or so, and then until the time when the Guayana Marine Agreement was signed. It was only signed in January 2010, and so I think we can look at the governance side on the First Nations, but I think you also have to look at the federal side. Is that often these kinds of arrangements, take some time, to move through, whether it's a First Nation process or a government process, and really that's, I think, where the political will becomes important. I think particularly if both parties might be ready to engage, but unless there is that kind of political will to actually bring that through and actually make a change, we're in some ways we're left in limbo.
I'm just going to switch focus and maybe go to Exhibit 493, Our Place at the Table. And these are some questions, I think, again, for Chief Jones. As I understand, you were one of the authors of that report.
That's correct.
If we can go to page 75, I just want to discuss a couple of the recommendations. And just while that's coming up, I'll just introduce this. I think Dr. Harris on Monday spoke quite a bit about the Bolt decision in the United States, and I think his view was that as a just result and something that he would recommend is appropriate for British Columbia, and talked a little bit about the Stevens Treaty and the decision in the Bolt case in the 1970s and the results from that. And if we look at recommendation number 2, and this is the one which provides more detail, my copy, provides more detail about this. Well, I'll just go to the recommendation itself. As a starting point and an interim measure, Canada should take immediate steps to allocate to First Nations a minimum 50% share of all fisheries, with the understanding that this may eventually reach 100% in some fisheries. Now, my understanding of the Bolt decision is that the fishery in the Washington state is shared, as a result of that decision, 50% between the Washington state tribes and the other fishers in the state. Is that correct?
Basically.
And the paper here notes that the allocation, as is based on Aboriginal rights and title, some fisheries may be allocated up to 100%. I just want to clarify what is being suggested here. I'm unclear whether you're recommending eliminating, first of all, the distinction between food social ceremonial fisheries and commercial fisheries on the Aboriginal side, as this was something that was recommended by Dr. Harris on Monday, and I'm just curious if that was something that you had discussed or is implicit in this recommendation.
I think in this recommendation, we weren't necessarily distinguishing between the, commercial or food social ceremonial fisheries, but I think it is speaking mainly to economic access, though, and even you mentioned Washington State. The 50% isn't based on Washington State. It was recognizing that Aboriginal title and Crown title, there's issues here in British Columbia, and so the rationale in this case, was that Aboriginal title is the underlying title, so an equal share, should be is a good starting point for balancing, I guess, those interests in fish.
And what is this, the 50% target that's set out here? Was that in some respects based on the Bolt Washington State model as a starting point?
I think if you read back in the report, I think there is a statement about the kind of rationale, and it gets back to what I've talked about, balancing Aboriginal title and Crown title. I think in Washington State, it is based on a treaty right, and interpretation of treaty language, right? Whereas we have the Douglas treaties here, but of course in the rest of the province we don't have treaties. So it's not just speaking to basically those groups that may have treaties similar to what there is in Washington State.
Okay.
And on the 100%, I think we were recognizing that there are some fisheries where there already is like this herring spawn on kelp fishery, where there is quite high First Nation participation, and we don't want to make a recommendation that we should reduce those fisheries. And I think also I heard yesterday, or day before yesterday, it was mentioned about, for instance, Early Stewart, which are mainly harvested in a First Nation fishery. There's also a potential U.S. share in some cases, but I think that we weren't going to say 50% when we recognize that in some fisheries there already is greater than 50% share for First Nations.
I guess where I'm going with this is I'm just trying to be clear in my own mind as to whether the expectation would be that the allocation of 50% or more, depending on the circumstances, would be that the constitutional priority recognized for Aboriginal rights would continue to be in place, or was it an idea of trying to adopt in total through agreement the Washington State model of 50% without the priority?
The constitutional priority, of course, would still be there because there are no treaties signed. This is proposed as an interim measure, a way of balancing the interests of the Crown with the interests of First Nations, and I think it's both the First Nation panel report and the Pearson-McRae report, recognize that this is an issue that has been outstanding for a very long time. And that if there isn't kind of, and so it's a recommendation to decision makers, basically that we need to address these issues, and it proposed a concrete step to address it. And the province, the federal government, through Pacific Fisheries Reform and then PICFI, on their side, took an initial step, of and addressing mainly the commercial access side of it. I think there is recommendation one, around food social ceremonial fisheries as well.
Okay.
And so I think it's, I think this really is a decision for individual First Nations to resolve in terms of their balance between food social ceremonial and economic fisheries. I think there are some examples of First Nations that basically manage both fisheries together. It's up to the fisher to decide what they'll do with the fish, right? Which is consistent with what Dr. Harris proposed. I think there may be other First Nations who would manage their own fisheries for that priority, for we call it traditional use. Haida, we don't call it food social ceremonial fishery. That is kind of a construct, of the current legal system. Rather than the way we see the fish.
I probably just have time for one more question. Sorry, Chief Terry.
Yes, I wanted to comment because of the fact that as the Intertribal Treaty Organization, we're very concerned about this as being a very important matter that needs to be where we need to be very cautious about in terms of saying that we're looking at a 50% start off for negotiations. And as Mr. Jones indicated, that there's no agreement between our nations and the Government of Canada in terms of fishery resources yet. And so I would take it that that is a matter that needs to be further discussed. And just also for clarification, I'm certain that there's greater understanding already, but just so that I can express it, is that when we say First Nation, we're what are we referring to? Is it a band or not? And when the ITO says First Nation, it is a nation. It is a grouping of communities that are coming together that form that particular nation. And so it's more of a one might say an international definition of what a nation is, and not as come to be understood as a replacement name for a band.
Just my last question, perhaps we can go to the bottom of page 75. And I just want to talk a little bit about the dispute resolution issue that Chief Jones, you discussed the other day. And this is recommendation 3, where it says First Nations themselves must address intertribal allocations. And right at the very bottom of that page, you refer to disputes arising over what constitutes a fair share are almost certain. For that reason, an effective dispute resolution mechanism is also needed. And then over the next page, we recommend that there be a coast-wide adjudication process or regional processes, and that they are binding on the parties. Is that feed into what you were suggesting the other day, Chief Jones, that this is something that perhaps it could be subject to some kind of judicial oversight, like in the Bolts scenario?
Yeah, I think that's a possibility. I mean, this is a recommendation. I think a recommendation that was made at the time, to First Nations as well as, the federal and provincial government. There hasn't been much further work done on this kind of approach. I think day before yesterday, when I was talking about oversight, I saw the oversight, as a way of both providing some more impetus to the process, and probably helping the negotiation by knowing that if there's a chance to try to reach agreement, but the parties can bring issues back to another, basically another party to try to get past impasses. And I think that did work, quite well in the United States, after the Bolt decision. The court had made a decision about the allocation, but basically how you would manage the fisheries was still, there were still a lot of questions, and both the tribes and often the state, brought issues back to the court to get direction on things they couldn't resolve, right? So I think that's one mechanism, and you could also have like this. This says having a binding process would certainly make it simpler, but you could also have other processes. And in the Guayana agreement, for instance, there also is a process of getting a third party, to review issues and provide advice to the parties as well.
And just my last follow-up question on that. On the next paragraph, you talk about Washington State and the Maori, and you go into further detail elsewhere in your paper. I'm interested in some of the principles that could be considered for this dispute resolution process. And it talks about the relative strength of Aboriginal treaty rights to the fishing area or stock. Is this something that you would also, as an option, have as a potential dispute resolution in a judicial oversight dispute resolution process? Some kind of process to include the relative strength of Aboriginal treaty rights. I'll await your answer, but perhaps while you're thinking about that, I'd like to go as my last document, Exhibit 295, Mr. Lynn.
So the intertribal, so I see this. I mean, this was a recommendation about intertribal sharing, right? So I think really I'd like to go back to revise my answer before, because I think that's really for First Nations to decide on the dispute resolution process. And the court or some other binding process might be something that First Nations would decide on, but really it's something that First Nations have to come to agreement on.
Right, and that takes me to my next point, which is Exhibit 295 on page 11. This is something that came up the other day, and the second, under policy barriers in the second bullet, and it talks about some of the 2 key policy barriers. And number 2 says, an inability for DFO to develop a process for the recognition of First Nations title and rights, or to lay out a transparent strength of claim standard assessment to evaluate asserted title and rights. Based on your paper, Our Place at the Table, and the recommendation that intertribal allocation should be determined by First Nations themselves, do you really want the Department of Fisheries to get involved in the issues of determining and bringing its perspective on strength of claim to the various First Nations in the province?
I think it would help to know kind of how the Government of Canada is currently deciding on allocations, and because is it based on strength of claim, or are there other factors? I know population seems to be kind of a factor that's being used in treaty negotiations more than rights and title arguments. Just as an example, the Haida Nation provided information, to the Department of Fisheries and Oceans back in 1998 about commercial Aboriginal rights to halibut and herring spawn on kelp, and we had very good information, and we've really received no kind of effective response or answer to how the Crown is addressing those existing Aboriginal rights. So I think it would be helpful to kind of to know how the Crown is approaching those issues, both in treaty negotiations as well as fishery allocations, whether it's through PICFI or others. But I think it is kind of better in some ways if First Nations together can work out those issues. And the Fishery Council has started a dialogue on intertribal sharing. Just earlier this month, we had a workshop where we talked about that, and is looking at are there some principles that can apply. In New Zealand, this was something that the Maori did. It took some time, but they went through that process. And so it is, in some ways, it's a way of bringing First Nations together, also having them work together more kind of in watersheds or around specific fisheries, which may make it easier to resolve some of the management issues for migratory stocks, such as whether it's Fraser sockeye or halibut or other species. And I think you have to recognize that Our Place at the Table wasn't just dealing with salmon; it's also dealing with a whole range of species. And for some you may need to work on have First Nations working together, kind of in larger bodies. In other cases, you may not need that. And strength of claim may be the major factor for a sedentary species like geoduck clam, right? Or maybe in the case of herring, where herring come back always to spawn in the same area. So that that may be more important in some cases, than other factors.
Chief Todd, Chief Terry, and Mr. Todd.
Thank you. I just wanted to make certain I've been listening, and a phrase that has been used here is title and rights and title. And I don't believe that they're interchangeable. I believe that there's a significant difference in law, and I really would be wondering how the Commission would be looking at that, the difference in those two phrases. So I just wanted to cite that because of the fact that we have a clear understanding of who has title in our homeland areas, and then the rights that are derived from that title. And it's quite specific, and the introduction of rights and titles is quite a different thing, I believe.
My time is up, so I should probably sit down, unless Mr. Todd, you wanted to.
Very quickly, to go back to your question about the policy barriers, number 2 in particular. The Department of Fisheries and Oceans mandate is based on, in quotation marks, room for all in the fishery. And that is obviously a government, a Crown policy. So hence, number 2, as it states, the inability for DFO to develop a process for the recognition of First Nations title and rights, because obviously to do so would seriously constrict that mandate, room for all. And so the department is not necessarily the root of the problem here that we're trying to grapple with. It's the Crown, it's the Government of Canada. So that's why that barrier was stated as it was, in my opinion.
Thank you. Those are my questions, Mr. Commissioner.
They're needed to feed First Nations people over the winter, and I'm not challenging that in any way. But I want to ask you, would you agree that Canada has a fiduciary obligation to provide the regulatory structure that will reasonably ensure that First Nations people do receive their food fish?
I think if from experience, if that were the case, then we'd have more confidence in the system.
Yes.
However, there have been numerous examples where there were promises made but not kept.
Yes.
But going back to the fundamental, though, of management, we feel that we had and still have the ability to manage the fishery within our respective territories, and that we're quite prepared to embark into a system or process whereby we can discuss how it is that we can properly manage the resource in order to conserve it.
Yeah.
Now, the other day I mentioned that maybe we concentrate so much on harvesting that we have lost sight of how to protect, enhance, and sustain the fishery within all areas of our respective territories.
Yes. Yes. Well, I don't want to ask you about that so much as the method of delivering fish to the people and First Nations communities. First of all, it's generally only a small proportion of the people in the community who do the actual fishing. Is that right, as a general rule? There are many elders and others who don't actually do the fishing.
Well, I do fish.
Yes.
So it depends on one's ability and capacity to be able to function and be able to go and actually catch their fish.
Yes. Yes.
We have had elders in my community, for example. We had an elder that was in his 80s, and we saw him carrying his dip net along with his knapsack and to the fishery, and then he in a number of hours later he was coming back with his sack full.
Yeah.
And so there is the capacity there, and we feel that we can. Those that need to replenish their fish stocks do that, and for those of us that cannot, then others certainly provide the means by which we can acquire the fish for the winter.
Yes, because the point is that all members of the community are meant to receive the fish that they require.
That's right.
Yes. And on the coast, the general situation is that there'll be a person with a fish boat who will go out and catch the fish and then provide the fish to other community members. Is that the...
That's my understanding.
Yeah. Now, sometimes it's been known that the fishermen who catch the fish will sell it for their own gain rather than distributing it amongst the community. You've known that to happen, I expect. Is that right?
It's certainly a practice that was it was done at the earliest days until such time it was outlawed
Yes.
from having to be done by powers that be back in Ottawa or
Yes.
local government.
Yes. So if a person, for example, catches 100 fish, he might, if he's looking to his self-interest, sell them. I think last year the going rate was about $20 a fish. That's $2,000. Or he might, if he's more responsible and appreciates the intent of the constitutional priority, he might distribute it amongst the band members. That's the choice that the person catching the fish has to make. Would you agree?
Well, self-interest. Are you describing then that the commercial industry is primarily involved in harvesting because of the fact of self-interest?
No. I was simply trying to get to this. How is the Government of Canada or the First Nations government, how can they take action to ensure that the people in the community who are not able to actually do the fishing, to ensure that they get the fish?
We sir, have our ways and means of distributing and sharing and making good use of the resource. And we contend that we have the means by which to make decisions on how best to use the particular resource that may be coming to or through our territory.
Yes.
And so that's the basis. The practices and use are well delineated, and we tend to observe them quite well, but too often they're interfered with.
All right. Well, I've got limited time, so I can't pursue that very much further. I'm sorry. Chief Jones, I wanted to ask you another question, but did you want to say something on this point?
Yeah, since you were talking about the coastal fishery, you know,
Yes.
I'm quite familiar with the coastal fishery, and so you were talking about people go out with their commercial boats to go fish for food, and you know that certainly was the case, you know, going back 30, 40 years in our area.
Yes.
But currently there's very few people that still have commercial boats. They've lost their basically licenses. Some cases have been sold, and so we have very few commercial fishermen left in our communities. So and in our community too, like Chief Salteri mentioned, you know, we have many people go out on their own, sometimes with skiffs, and we go out and catch our own food. And on the issue of sale of fish, I mean, I know you're well aware, you know, that, you know, with the Aboriginal Fisheries Strategy, I mean, there were initiatives that were put in place to try to address some of the issues you're talking about. There were some pilot sales programs, you know, one in the Lower Fraser, you know, there was another in Skeena, you know, another over in Barkley Sound, you know, which in which there was a communal license issue that did allow sale and was negotiated, you know, between the First Nations, you know, and that were involved in the fishery, and I think, but there was a commission that was held shortly after that said that said that there was no more pilot sales going to be negotiated. And so we went through a number of years, where those mechanisms weren't available to us. And it's really only through this new PICFI program, where again, there's an opportunity to try to accommodate, I guess, those issues around the interests of First Nations aren't just in the food or subsistence fishery. I mean, they are also for economic benefit from the fisheries, similar to many other Canadians.
Yes. So I gather what you're saying is it's important for the coastal communities to maintain their presence in the commercial fishery, because having the boats there assists in delivering the food fish to the people in the community who don't have a boat.
That is certainly one part of it, but what I know in our area too. I mean, we've been seeking for many years are allocations of fish. So basically, we can manage our own fishery, and again, we can determine the type of use that we want, whether it's use it, as a food fishery or for economic purposes.
Yes, but there's a constitutional duty to deliver food fish to the weaker members of the band, is there not?
That's a question of law.
All right, I'll leave that. I'm sorry. And I've got limited time, as I say. Chief Jones, I wanted to ask you this, something more about the coastal First Nations. You owned a boat yourself, I see, from your CV from 1979 to 1985. Is that correct?
That's correct.
Yeah. Was that a trólar?
Yes, it was.
Yeah. Your father, I think, was a good fisherman as well, and a good shipwright. Is that correct?
That's correct.
Your grandfather, Albert Jones, was a renowned fisherman as well, and a prospector. Is that right?
Yes, he was.
Yes. Am I right that in 1958, you may have to answer this in general terms, but I understand that in 1958 there were 52 trawlers in Skidegate when the population was only 213. Does that sound about right to you?
Yes, it does. We've had many people talk about the loss of access in Skidegate.
Yes, and there's been a loss of access, and the Haida Nation is pressing for a restoration or a greater access to the commercial fishery, correct?
Yeah, fisheries is one of the few kind of economic opportunities in our area, and
Yes.
We have large fisheries, something like 18% of all the commercial values of all fisheries occurs around
Yes.
in our waters, and we would like access to that.
Yeah, and there's a similar story in other communities, Port Simpson or Lax Clemens, Kitkatla, Metlakatla, Hartley Bay, Klemtu, Bellacoola, Oakino, Alert Bay, Fort Rupert, Quatsino, Cayucot, Zabelis, Ahousaht, Ucluelet. A similar story. A former presence in the commercial fishery that was greater, a very much a need for a commercial presence because of the remote location and dependence on the sea, and a pressing desire to have a greater presence today. Is that pretty much a common theme?
Yeah, I think that's if you go back historically, certainly that's what's happened is, and a lot of that has been through, licensing policies, and sometimes it's, like buybacks. It's also been new fisheries like shellfish fisheries, dive fisheries for geoduck or sea urchin, and basically, and in those policies, there hasn't been, we would consider there hasn't been fair distribution, I guess, or access for First Nations in those new fisheries.
Yes. The fishermen in the past decades in your area and other coastal First Nations have made huge contributions, haven't they? I'm talking about people like Dempsey Collison in your area, Roy Jones Sr., Paul Pearson, Willis Crosby, Sidney Crosby, all Haida, I think.
Yes,
fishermen.
yes, they are. They have been very.
They all made huge contributions to the communities, did they not? In terms of employment and economic well-being.
That's right. It does make a big difference having someone in the commercial fishery and having a commercial fishing business or a vessel.
Yes. And the same thing in Old Masset, there Robin Brown, Wilson Brown, Jeff White, Oliver White, and lots more.
Yeah, and of course, I don't think any of the ones you've mentioned are still involved in the commercial fishery.
In the Alert Bay area, the Asus and the seaweeds and the beans families who've been in the fishery for generations, you aware of that?
Yes, I am, and I think it's the same situation. Even in many of those communities, there's very few boats
Yes.
or licenses.
Fort Rupert, James Walkus, Walter Cadwallader, Alfred Hunt. I think those three are still involved in the fishery, aren't they?
Possibly.
Yes. Campbell River, the Roberts and Chikites families, they're still involved in the fishery, I think, aren't they?
I know the Roberts are.
Yes, all right. And the coastal communities all have this in common, don't they? That they're remote communities, many without even roads to them, and they have minuscule reserves, correct?
Yes, I think Doug Harris spoke to
Yes.
that as well.
And Doug Harris showed us a map showing that the upriver reserves were larger, and he explained the agrarian purposes for those larger allotments.
Sorry, I don't think that's a correct summary of the
Well,
evidence.
There was a chart that went up. That's what I was referring to.
Larger is inaccurate, I think, even if you reflect on the chart.
All right, well, the chart speaks for itself. Chief Jones, do you have a view on that subject? Is that not a well-known subject and something that's often discussed as between coastal First Nations and upriver First Nations, that they got the larger reserves based on the idea that they were to derive their income from land? Coastal First Nations were expected to derive their incomes from the sea and got smaller reserves.
I think in the Haida Nation, our approach has not been to look at the size of reserves. It's been around our historic occupation and of Haida Gwaii waters, and so and you're aware that the Haida Nation has case for Aboriginal title to all of Haida Gwaii and the waters around Haida Gwaii, and that's it's currently in abeyance, and we're involved in reconciliation discussions. But I think that's our approach. Hasn't been focusing on these reserves. I know when the reserves were surveyed in our areas, my great-grandfather Amos Russ, testified before the Reserve Commission, and they said that we own all the area. And these are areas we use, but we're not going to put forward a list of areas to be set aside as reserves because we own the whole area.
Yes.
That was back in the around 1910.
All right. We've heard evidence of pick fee licenses being taken from the coastal areas and effectively, the allocations effectively being transferred upriver. In the West Coast Vancouver Island area that my clients are in, or one of my clients in particular, there are 14 pick fee troll licenses, and we heard that a lot of those are being transferred upriver. Now, after the Court of Appeal decision in the Housett case, I think the DFO is finally looking to leave them in the coastal areas. Do you have a view as to the transfer of commercial fishing opportunities away from the coast upriver, Chief Jones?
I know that the basis for that, there's both an issue of justice, in terms of because they're First Nations up the river. We heard about the barricade treaties have been denied commercial access, and then I think the other issue has to do with I've lost my train of thought.
Yeah, so did I. By my reckoning, I've got 5 minutes left of my. I've got one more topic, if I could.
I don't think you can get on that last question and answer.
No.
Maybe you want to try that again.
What does he think about? What do you think about commercial fishing rights being taken in the pick fee program from the coastal areas, transferred upriver?
Yeah, so the other issue is there's a conservation issue. So basically a movement towards more terminal fisheries, puts less pressure on weak or species at risk or stocks at risk.
I know that's the DFO position, but how does it affect coastal First Nation communities who cannot get those pick fee licenses?
I think there's an opportunity for terminal fisheries in coastal areas as well. So I think that's one way of kind of addressing that, but current DFO policy doesn't allow that discussion. The allocations are currently, can be discussed and negotiated for inland fisheries, but coastal First Nations just have to have licenses. So I think there are some opportunities for terminal fisheries in the coast that should be explored.
But I thought the object of the pick fee license scheme was to buy licenses out of the non-Aboriginal commercial fishing users and transfer them to First Nations for commercial fishing purposes.
Yeah, I think that has been happening, and some of those licenses I think have been used for economic opportunity fisheries inland, and First Nations that basically include salmon licenses in their business plan also can have access to salmon licenses that have been retired, and there also is a mechanism to avoid kind of disproportionately affecting certain categories of licenses, whether it's an AI license, which is that can only be held by a First Nation.
All right. Well, I won't press you further on that, but there's one other topic I wanted to ask you about. Oh, Chief Terry.
Yes, I'd like to comment on the point that you're trying to make in terms of moving a particular program around or utilizing it to manipulate management of commercial interest. From our point of view in the ITO or the Intertribal Treaty is that we have the right to determine how it is that we shall use the resource. And currently, however, we have a problem in terms of adequacy of the stocks to be able to utilize a more wider scope of economic enterprise. Also, I think that we're getting into more of how is it that these particular programs are being established, and I think that there's a fine point, Mr. Commissioner, that whereby there's a political reason for incorporating these programs to the interior, and there needs to be find a way in which we, the people, can determine how it is that an economic venture is to be pursued.
Yes, thank you, Chief Cherry. Now, finally, this very important subject of the model. On the west coast of Vancouver Island, there's an aquatic management board model that's been discussed here, and as part of its website material, it has this under the heading of inclusivity. And I'm going to ask Chief Jones how this compares with the Guyahanas model. Inclusivity: coastal communities and other persons or bodies affected by aquatic resource management should have an opportunity to participate in the formulation and implementation of integrated aquatic resource management decisions. Participation of coastal communities and other persons and bodies affected by aquatic resource management will promote improved decisions. On the Guyahanas model, there's a board of 6, 3 of which are Haida and 3 of which are Government of Canada. Is that correct?
That's correct.
No non-Haida communities represented or non-Haida stakeholders?
There was an advisory board which was established, which was made up of mainly community members, there was representatives from the commercial fishing industry who worked to recommend an interim management plan for the
Yes.
area, and that was something which was, adopted, by this is for the marine area.
Yeah, but it didn't affect the board members, and out of the members, some of the Canada board members were in fact Haida Nation persons. A gentleman by the name of Gladstone, who was the park manager, was on that board for a time.
Yeah, there's, if you're referring to the superintendent of Guayhanas,
yes.
you're correct, he is a Haida.
Yes.
And he's been involved in kind of in that organization,
Yes.
For the last 15 or so, 20
Yes.
years.
Now that model is applied on in Haida Gwaii, where about 50% of the population is non-Haida. Is that approximately correct for the population mix?
Roughly.
It's led to a certain feeling in the non-Haida citizens that they've been disenfranchised, has it not? And it's led to some litigation.
There's been, I think there's a lot of support for, like I mentioned, there's an advisory board that was involved in developing an interim
Yes.
management plan. And certainly there always are individuals who won't agree with things that, whether it's government does or whether the Haida Nation does. And, yes, there was a court case that
Yes.
was, I believe, was a tour operator who wanted a larger allocation of visitor days.
Yeah, well, his quota was determined by this board, and the board adopted a rule that if you wanted to increase your quota allotment, you had to be a Haida blood. You had to have a blood connection with the Haida Nation. Is that correct?
I don't think that's correct. There's under the management plan, there's a limited number of visitor days,
Yes.
and those days are allocated. There's a certain number that were allocated to existing users, of which there were no Haida involved.
Yes.
And then there's also an allocation that's in place for future Haida, future Haida businesses, and so and that was based on kind of their historic visitor days, right? And so there was one operator who wanted to expand their business, but and then that was what the court case was about.
Yeah, and he couldn't because he wasn't Haida. If he had been Haida, he could have. That's what it comes to.
Well, he has a license and he's operating under a certain management plan, and I think he would have liked to change the management plan.
Yes.
But I think it went through a public process, it was approved by,
Oh, yes.
the government of Canada, and the Haida.
Yes.
And,
Yes,
and
yes.
that's being followed in management of the area.
Yeah, but you mentioned this model, and you mentioned Inuvialu agreement that is a similar model, but that model has never been used in a southern Canadian context for the allocation of commercial rights of access to a public resource, has it?
In a Canadian context?
In southern Canadian context, geographically.
I didn't mention the Inuvialuit model, although I know about it.
All right. Well, I'm sorry, my time's run out. I can't pursue it further.
Perhaps an appropriate time to take a short break.
We will now recess for 10 minutes.